Good day, folks. You've arrived at another installment of KingCast Mortgage Movies, and I'll be writing Attorney General Ferguson for an advisory opinion as to whether inspection of a public document in a public building is an event that is or could be, ipso facto private. But before we get there, I want to note to the court that there is case law, such as Wright versus J.P. Morgan from just last week in Florida, no less, a foreclosure mecca, holding that the parent corporation does not inherently have vested rights to conduct business under the name of the subsidiary, as implied by Deutschebank counsel J. Will Eidson in court last week.
Well, what I want to do is video them in the hallway doing this examination of a public document. Do you follow me?
And the judge is not going to take the bench.
Thank you.
You're welcome.
Well, I don't know what they have to hide. Will, what do you have to hide? Counsel? Well, Mr. Eidson, I'm not sure about that. This is part of a public proceeding, sir. Counsel, this is a public proceeding. Don't shut the door on me, especially not on video. You know better than that. Oh, no, you got to cancel it? This is part of it. Your Honor?
Now, J. Will Eidson certainly hates my cameras. Last week, I went on down to court on a summary judgment motion by Deutschebank that was denied. Now, to understand his hatred, you need to see how I confronted him on a completely bogus federal removal on a case where they wanted to get away from Judge Bowden, who had on prior occasion reversed a fraudulent foreclosure sale in front of my cameras in Bradburn versus Recon Trust. Here's the confrontation from that event coming up for you, followed by last week's shenanigans, where Attorney Eidson did not want me to be present when he participated in an inspection of a purportedly original note. I don't know, Lucy. It looks like they've got some splaining to do. Look at the date of the purported security instrument on her purported loan. Okay, it references 31 July 2006. The purported note itself reads 25 July 2006. And oh, Ms. Shcolnik says that her Canadian Border Patrol docs prove she was out of the country all day on the 25th. So are they claiming she signed it at night? Well, then if so, the people who signed the deed of trust have to testify, rather than Attorney Eidson. That's pretty simple, folks. Law School 101. We'll see if the court gets it right.
I'm wondering, so now, did you have first-hand knowledge of any of those things that you attested to in your declaration, sir?
You can keep asking questions, but I'm not going to answer your question.
That's fine. I'm going to keep asking them. That's what I do. Yep. On the removal, did you clearly see that she did not state a cause of action for FDCPA? Did you notice that there was a difference in the language there when you went to remove the case? And also, your partner did that, John Glowney. Now, let me ask you this. Did he do that on behalf of everyone? Was there mutual assent ever manifest in this case by all the defendants to remove the case? Because I didn't see it. Counsel.
Excuse me.
Counsel. Have a nice day. We're here at KingCast Mortgage Movies. We're here at KingCast Mortgage Movies, and we're here with the Ericksons. This is Deutschebank versus Erickson et al., and I believe there's a forensic specialist here who is going to examine the original note. However, the original note is not present. Is that correct?
They're supposed to be bringing the original note. They said they were going to bring it, but they were supposed to be requested to bring it early, and they have not shown up with it. They're saying that somehow we waived our rights, even though they agreed to let us examine it. They're saying we waived our rights now to examine it.
Mind if I take a look at that, counsel? Is that the original note?
That's what I'm told.
Two reasons we're not going to make it available.
What is that?
One is we objected to the notice. We agreed to...
You objected to the notice?
To inspect, yes.
I cannot see an objection in the file.
There is one.
Huh?
There was one.
There was in the court file?
Filed on March 18th. Well, it's not the court file because it's a discovery.
Okay.
So we did not file our objection. But we said you can view it at our office pursuant to your request, which was 21 days from our response. Our response was March 18th.
Well, Mr. Eidson, I'm not sure about that. This is part of a public proceeding, sir. Counsel, this is a public proceeding. Don't shut the door on me, especially not on video. You know better than that. Oh, no, you got to cancel it? This is part of it. Your Honor? No, we're going to have the judge on this.
You can't be in there when they're conferencing. This is, hold up. This is open to the public, the courtroom, but not when the parties are conferencing. The courtroom is open to the public.
Well,
Yeah.
if I may though, I'd like to pronounce her from Her Honor on that, because this is still a public event, okay? They're not having a settlement conference. You know, I was a practicing attorney for years, okay?
Okay,
I understand the
I read
concept
it, but
of
you're not
that.
going to be able to go back there. I mean,
But I need to
then
hear
the
that.
judge is not going to take the bench.
Thank you.
You're welcome.
Well, I don't know what they have to hide. Will, what do you have to hide? Counsel?
You see, I need that, I'm going to write a request for an opinion from the Attorney General's office. They're not in a settlement conference. I can understand that, okay? This is not a settlement conference. This is an examination of a public document.
You've been given an answer.
Right.
That is a conference room. Nothing's going to change. You're not allowed to go into the conference room.
What if they were examining it out here? Could I videotape them out here?
All right. No, it's not. It is what it is. I'm not trying to, I'm going to treat them the way I would anyone else. No.
I want you to do it out here or in the hallway, because they said it's a conference room.
No.
Okay, what can you do in the hallway?
Might be a little more difficult, but I can.
I want it public. Everything that I do is public.
Sir,
If he chooses,
This is the bottom line.
not in here, not in the conference room, right?
If they want a conference in that room, the judge is not on the bench. The judge is not on the bench. It is no longer public when the judge is not on the bench.
Right.
So both lawyers must agree that you can videotape them, both lawyers.
Well, now wait a minute. This is still a public building, okay? And Mr. Eidson, well, this is my life. Wait a minute. I was a First Amendment attorney for years. I'm not through. This is a public building, okay? And by dint of them being in a conference room.
When I say I'm through with the discussion. But you can do what you want to do, but I'm through with the discussion.
Well, what I want to do is video them in the hallway doing this examination of a public document. Do you follow me? It's a public document, right? We're here with KingCast Mortgage Movies, and the situation here is that the forensic examination of this alleged note is about to occur in this room. Now, Attorney Will Eidson didn't want it to occur so that I could video it. So he, basically shut the door on me, and the judge did not take the bench to give an opinion on that, but the bailiff came out and said, no, I can't do it. So I'm going to have to accept that for now. But in the future, when forensic examinations are done, I'm going to see to it that they're done right there in the hallway. That's a public area, not a conference room. Even though they're not conferencing on settlement. This is a very interesting phenomenon. And why is Mr. Eidson so opposed to having me videotape this? If he were on the up and up, he wouldn't get it, would he? But he doesn't get it, because they're not on the up and up. KingCast Mortgage Movies, thank you.